Hello everyone, this is Samsung X from the East China University of Political Science Law. This is my second lecture on patent law in China from a comparative perspective. This lecture is composed of 4 sessions. Session 1 will give you an overview over the exclusive rights granted to a patent owner. Session 2 will be around topic who is an inventor and who owns the rights over a patent. In many cases, it is not the inventor who owns the patents. Section 3 Patent Infringements. A patent grants the patent owner a group of exclusive rights to authorize the doing of certain acts restricted under patent law. Without permission, the doing of those acts would be infringing directly. However, indirectly, a third party who facilitates the doing or contributing to the occurrence of a direct infringement might also be held liable for infringements. Section 4 Defenses to infringements and remedies for infringements. The exclusive rights granted to patent owners are not without limitations. This session is about the defenses to claims of patent infringements. You will see potential defenses to patent infringements include the exhaustion of rights, prior use defense, innocent self-infringer defense. The remedies available to patent owners in China include the rights of asking the courts to issue injunctions and the rights to claim damages and more. Section 1 Patent Rights. Generally speaking, a patent grants its owner the exclusive rights. Exclusive rights means the patent owner would have the rights to exclude or stop others from the doing of certain acts. Majorly, those acts related to use the invention for the commercial purpose. For example, for the purposes of a production and business operation. It means the implementation of an invention for private purposes does not amount to infringements. It might be okay for you to make a patented products at your own home and use it for your own purpose, or make the products for research purposes. But you cannot sell those products made by you on the marketplace. That would be for commercial purpose. The rights granted to a patent owner generally similar to the owner of patents granted to all kinds of inventions, utility models, and designs. However, there are visible differences between the scope of those rights and even the types of rights granted to each categories of inventions. For instance, in the case of patented products and utility models, those inventions are tangible products. So, under patent law, the rights granted to a patent owner is the right to authorize the doing of the following 5 acts, which are the rights to make the patented products. Number 2, to use the products for commercial purpose. Number 3, offer to sell. Number 4, to sell. Number 5, to import. It might be easy for you to understand the rights to authorize the making of the products. Again, as we mentioned earlier, it is not infringing to make the products for private purposes, not selling it on the marketplace for research purposes, for example. And the rights to use the products, it means even you purchased a patented products, an infringing patented products on the marketplace and use it for your protection. For instance, you bought a machine for your factory. The machine may amount to patent infringements. The maker of the machine, the seller of the machine, should be liable for patent infringements. And you, the buyer and the user of the machine, is also liable for patent infringements because you use the infringing products, the infringing patented products for commercial purpose, which is to use it in your factory. Number C, offer to sell. If you're operating a website or a virtual shop on Taobao.com or eBay, the listing of those potential items potentially to be sold to buyers would constitute patent infringement. You displayed the infringing items through the windows of your shop on the street or to make advertisements, commercial promotions, inviting potential consumers to buy the patented products without permission from a patent owner would constitute patent infringements, infringing the rights of offering to sell. Sell. You transfer the ownership of the infringing patented products to a potential buyer. Selling would be established upon the signing of a contract for selling the infringing products. It's not always a case where the infringer has already transferred ownership of the infringing products or delivered the infringing products to the buyer. So a mere conclusion of a sales contract would be sufficient enough to be held liable for selling a patented product without the permission of patent owners. Importing infringing products which are made elsewhere in another country is an infringement. An invention might not be patented in all over the 200 countries and regions in this world. So it is legal to make the patent products, to sell it on the market, and to use it for any purposes in a country where the invention has not been patented. But it would be infringing to import the products made in those countries where the invention is not patented to a country where the invention is patented. For example, someone patented an invention in China, but not with the Japanese patent office. In this case, it would be legitimate to make the products, to sell the products on the market in Japan, but it is illegal to import the product from Japan to China. So, considering the patent owners are granted a set of exclusive rights controlling the doing of different types of acts, of course, it would be highly possible that the doer of those acts are not the same person. The one who, having made the infringing product without permission, will be held liable. The user of the infringing products for commercial purpose will be infringing, and those who selling those infringing products, importing the infringing products. So they could be different infringers. In the case of patented method or process, the patent owners own the rights to use the patented method for production. A patented method is about ideas to make different kinds of products. So the protection conferred by a patent for a method can, generally speaking, be divided into two groups. Group A, the use of the patented method. Apply the patented method for production, making products. Number B, the protection available to patented method is much beyond the rights to use the method itself, but also to control the use of the products which are directly obtained through the use of the patented method. For instance, someone invented a method to purify mineral water. or the water from the ocean. The final product is not special at all. It's just water. But the process to make the water, to purify the water from the ocean, is patented. In this case, it is infringing to use the patented process to make the purified water. It would also be infringing to use the water itself, which is the final product, for commercial purposes. Secondly, in the case of patent process, the patent owner would also have the rights to authorize the doing of offering to sell, selling, and importing the products directly obtained through the patented method. So here, what you should keep in mind is the exclusive rights granted to a patented process. It's not just a right to use this invention, which is a method, an idea to do things, but also to use the products and offer to sell or import the products directly obtained through the patented method. In addition, in the case of patented process, it would be more difficult to establish patent infringements because the final products of a patent method, the final products which be made using the patented method, would look no different from the product made by other means. For instance, the patented method to purify water from the ocean, the final product will be just water. The water derived from the using of this patent method will be no differences from the water that were made available by other means. So it will be very difficult to determine whether those bottles of water which were made of the patented method or not. As you may see, in the case of infringements on a method patent, it is tremendously difficult for the patent owner to prove the products at issue was made through the process patented by him or her. In practice, special rules have been established to determine whether the method applied for making the product at issue is a method patented by the plaintiff or not. We will be back to this topic later. In the case of patented industrial design, the exclusive rights conferred by a design patent are the rights to authorize the doing of the following four specific acts. which are the acts of making of the products with the design, offering to sell, selling, and importing the products. Comparing with the acts subject to control of an invention products, you will see for the patent owner of an invention patent, he or she may control the doing of 5 specific acts: making, using, offering to sell, selling, and importing the products. Whereas in the case of design patents, the patent owner does not have the right to control the use of the products with the design patented by him or her. It means it is illegal, it is infringing to buy an infringing patented invention products and use it for commercial purpose. For instance, you are operating a factory, buying and using an infringing machine would constitute patent infringement, because the mere use of infringing machine would constitute patent infringement. However, in the case of industrial design, it is not infringement to buy an infringing design products and use it for any purpose, to use it for private use or to use it for commercial use, because the patent owner of a design patent does not have the rights to control the use of the products. Whether buying infringing products may give rise to infringements, the answer is no, because under patent law and any intellectual property law, the exclusive rights granted to the IP owners are only the rights to control the doing of specific acts which are clearly defined under patent law, copyright law. So here, buying infringing products, infringing patent products, is not an infringement. It would not give rise to liabilities for buying an infringing item. But it might be infringing to use an infringing patented invention products. It depends on whether the IP owners have the rights to control the use of the products or not. So here, in the case of industrial design, the patent owner of a design product does not have the rights to control the use of the products. The legal protection available to a patented design may only extend to identical or similar designs which are applied to identical or similar products. It means when the designer, when the applicants applying for a design patent, the applicants must pick up from the classes of products for which the design will be used for. For instance, if this is a design for the bottle of Coca-Cola, it is infringing to produce those bottles and the products of Coca-Cola with this design. However, if you use a design to make a giant building or to make a furniture or anything else which looks exactly identical to the shape, to the pattern, to the color of this design, it is not infringing the patented design rights. How to determine whether two designs are all identical or similar? This is a very important question. While in the case of infringements, of course, the plaintiff must establish that the product at issue made by the defendants looks identical to the plaintiff design or similar with the plaintiff design. The rules to determine whether the two designs are identical or not has been developed through many years of practice in the courts. So now it's been quite clear that it should be decided from the perspective of an ordinary consumer. Not an expert or a professional designer. And assessments should be based on the shape, the patterns, and the colors of the products. The design features indicated in the drawings or photographs contained in the documents submitted to the patent office for patent application should be examined to determine whether a design is identical or similar with the design at issue. So it should be assessed from the perspective of an average consumer for these products. And from the perspective of an ordinary consumer, it's the total, the overall visual and ornamental effects of a design should be the key points to be assessed. You cannot just separate one element from the rest of them. But any features contained in the design that are related to the functioning of the products must be excluded from assessments. Why? Because the protection for a design patents is merely limited to the ornamental or visual effects of the design. A design patent has nothing to do with the functionality of the products. So the scope of protection for a design patent is limited to the appearance of the products. The design simply for the purpose of making the products looks nice. In practice, the course has developed a number of specific rules to determine whether the design at issue, the products made by the defendants, are identical to or similar with the design patented by the plaintiff or not. And also the rules to determine the burden of proof is also being quite clear. So if you take a look at this case decided by the Supreme Court, or this is a leading case delivered by the Supreme Court, you will say the court has been focusing on what the scope of the design features at issue, which is important to answer whether the defendant's products or the design used for the defendant products may fall within the scope of the design patent owned by the plaintiff. Number two, usually it is the plaintiff, the patentee, to bear the burden of proof to convince the court whether the design features contained in the application documents is clear or not. If it's not clear what exactly the design features are, and also the courts being clear to exclude the protection of a design that might be relating to any functional features of the products. As we mentioned earlier, the patent owner of an industrial design only have the rights to authorize the application of the design for products that are identical or similar with the products that is the subject of the design patents. Put another way, when you apply for a patent for your design, you must indicate which, or you must make it clear to the patent office in your documents what is the specific class of goods for which your design would be useful. Here, the courts should determine whether the types of the products is similar to identical or is similar or identical based on the purpose of the product subject to the design patents. For instance, this design patents was made for, as I mentioned earlier, for instance, for the bottom of Coca-Cola. So that's a design of the bottle of Coca-Cola. So that's for that specific types of products. Whether the design used by the defendants for that product at issue is identical or similar with the plaintiff design should be assessed based on whether, number one, the two design at issue, the design from the plaintiff and the design used by the defendants, are identical or similar. Number two, whether the goods for which the design being applied for is similar to the products made by the defendants. And how to determine whether the products are identical or similar, or identical or similar types of products. The products for instance, in the case of Coca-Cola's bottle, for selling Coca-Cola, the plaintiff design is for the purpose of selling the Coca-Cola with that bottle. However, the defendant's products is for instance, is the milk. So there's a bottle of milk. Would that be infringing? You say milk and Coca-Cola, the different kinds of drinks. So the rule here is that the court will determine whether the two types of goods here, the two types of products here, they're identical or similar to each other or not, based on the purpose of the products, subject to the design patents. So the purpose of the design for Coca-Cola's bottle is to use the bottle or for the selling of for drinkings, and to determine the purpose of products, the courts may refer to the brief description of the design, what the design was originally initially used for, and the international classification for industrial designs. Number three, the function of the products and the situations of sale and actual use of the products. The point here is when the designer applies for a design patent, it is for sure he or she can only pick up one class of products for which the design would be useful. So that's a specific class. Whereas in the case of patent infringements, the class picked up by the patent owner is not the only factors to be considered by the courts to establish whether the defendant's products may fall within the scope of the products defined by the plaintiff, by the patent owner. It might be possible that these design patents initially was nominated for the use of Class A products. However, those products in other classes might be very relevant or very close to the products in Class A from the perspective of an average consumer. So the court will consider many factors to determine whether the products at issue are identical or similar with each other.